I am Marina da Bormida. Today I would like to introduce how to fill up the gap on technology and law developing at different pace in the post-truth society for delivering values for individual and business. We are assisting to a fast changing technological environment characterized by disruptive technologies such as big data, analytics, artificial intelligence, machine learning. On the other hand, the regulatory landscape is not advancing at the same speed, and it risks to be out of date or redundant by the time and it is implemented. The question is how to close the gap, but should it be closed? We are now in a moment, in a period where we are assisting to a new source of regulation. The regulation as a code, where there is software, algorithm, and hardware are imposing themselves as a new form of regulating social interaction, online communication, business transaction. This is not new because in the Lauren Lessig book of 20 years ago, The Code and Other Law of Cyberspace, he pointed out this concept of the code is law. But does this represent a threat or a promise for civil liberties and fundamental rights? And he asked this question to himself. In particular, what values should be protected by the technology? In fact, cyberspace, as any environment of human environment, requires choices. Now, we are no more only in the code is law time, but we have assisted to a shift towards an evolution of the law is code. New challenges are raised by blockchain, smart contract, and machine learning. And so now we have code-based rules automatically executed or enforced by the underlying technology. So technical rules are quite different from traditional legal rules. And this kind of transition characterizes both private sector and public sector. An example of this shift towards technological based rule are the data sovereignty platforms. We can mention, for instance, the one which is becoming a standard developed by International Data Space Association, which is a big association participated by more than 100 members in 20 countries. And this is an example of how it is important to consider the cross-intersection, the cross-fertilization between technology and law. In fact, this kind of solution provides factual exclusivity of data through technical measure and the combination of them with agile contracting. But these code-based rules have a number of advantages. For instance, the enforcement of rules and regulation at the beginning, a priori. But they also have a number of concerns, of limitations and drawbacks. For instance, we can mention the rigid and formalized language of code law. So now the question in European Commission and in the ecosystem of service of actors such as BDVA, Big Data Value Association, is around the fact if it is necessary or not to move beyond traditional approaches to regulation. In fact, we have now adaptive systems, autonomous systems such as AI and similar systems. They learn from their mistakes and they evolve, continually evolve. And so the question is if we need that also regulation is in some way adaptive and evolving. And so this is a real problem because fundamental rights and fundamental legal principles are at risk, such as the legal certainty, which requires that the regulation is foreseeable. There are a number of other ethical risks and challenges raised by this shift towards code-based rules. For instance, we can mention the risk of technological determinism, the risk of discrimination, manipulation, and misuse, the algorithmic bias, the lack of transparencies. But one of these on which the debate is now focusing in the so-called social cooling. The social cooling means the fact that we live in a reputation economy where our behavior, including online behavior, is given a score. And so there is the risk that in order to achieve a better score, people tend to apply a sort of self-censorship and to adapt their behavior to what is standard. And so there is the risk as a society not to grow, not to evolve. Which can be one of the solutions? One of the solutions which is based on the intersection and cross-fertilization between these two aspects, law and technology, is the ethics and law by design. This means that technology should embed and promote ethical and legal values since the very beginning of its design. We have talked of Lessig and the fact that we need to make some change and some choices. And the human choice of code-protecting values instead of making them disappear is a choice that helps us to have a value-driven innovation. A number of initiatives worldwide are moving in this direction. But which are the values that should be encompassed by technology? There is a common understanding of equality, predictability, fairness, accountability, transparency, human autonomy, and human dignity. The European Commission is working hard on this, and in particular, it appointed an expert group on AI, which prepared the ethics guideline for trustworthy AI. This was elaborated and prepared last year, and it is under a piloting phase, and it is expected a new release in the next months. Another initiative, this time at global level, is the Global Initiative on Ethics of Autonomous and Intelligent Systems, which is aimed at ensure that every stakeholder involved in the design and development of this kind of system is educated, trained, and empowered to prioritize ethical consideration. This, at the end, consists in a set of standardization projects, each of them focusing on different aspects to achieve this goal, such as privacy, well-being, and personal data AI agent, and so on. There are several hundred participants from 6 countries to these initiatives, and it is to be monitored to assess what will happen next. An example of a solution, a trend in this direction is the data-driven collaborative intelligence for materializing human factors, principles, and values. It is also aligned with another initiative of the MIT lab, which is the Council on Extended Intelligence. We have only the different term on the same or similar concept, collaborative intelligence and extended intelligence. But this means a sort of translation from artificial intelligence towards extended intelligence, where extending is in the meaning that it should enhance and complement human capabilities and knowledge. Technology as a complement element of humans. A promising area of application of this solution is the manufacturing domain, and it is aligned with the European Factories of the Future Association vision. And another tool, beside the ethics by design approach, is the regulatory sandboxes. This is under examination and experimentation in the European context. It started in the fintech universe, but the discussion is now if it is useful to extend to other sectors. What does it mean? It means that there could be places, safe place, where to experiment a new form of regulation to better align to technological development. An important point is that technology should prioritize different interests, and it is necessary to seek a balance between opposite interests at stake, such as the common good, the private interest, and of course, individual rights. Another point that is under discussion is the possible role of the soft law in, towards achieving better alignment of regulation and technology. As a concluding remark, we can say that there is not only one solution. It is necessary to have a holistic framework mixing different tools, such as ethics by design, worldwide liaison between different initiatives, accountability mechanism such as the ethics officer inside the companies, and also certification processes, and in the end, to foster cross-fertilization between law and technology. Thank you.
Thank you for that thought-provoking presentation, Marina.